Welcome back. We are jumping straight in today because we've got a highly requested, super focused explainer for you. If you're prepping for your exams, you already know exactly how tricky the procedural and maintenance sections of the Hindu Marriage Act can be, right? So today we're taking a magnifying glass to the HMA, specifically zeroing in on sections 24 through 29. We're going to lock in the case law, the timelines, and the exact statutory provisions you need for a foolproof, structured exam recap. Let's do this. Okay, let's dive into this. Here is the mental scaffolding we're building today. 1. Interim maintenance. 2. Permanent alimony. 3. Child custody. 4. Property disposal. And 5. Appeals and validity. Having this exact structure in your head is absolutely crucial for navigating those tricky exam questions.
All right, Section 1, Interim Maintenance, under Section 24 of the HMA.
So this is your starting line. When a matrimonial dispute kicks off, basic financial survival is usually the very first concern. Legally, we call this maintenance pendente lite, which literally means maintenance pending litigation. Now, pay attention here, because this is a classic exam trap. This applies to either the husband or the wife. Do not just assume it's only a remedy for the wife. As long as the applicant can prove they don't have an independent income to support themselves, the court can actually order the respondent to pay both the legal expenses of the proceeding itself and a monthly maintenance amount.
And since this is quite literally about immediate financial survival, the law mandates speed. Courts are directed to dispose of these Section 24 applications within a strict 60 days of the service of notice. So lock that number in your brain right now, 60 days for interim relief. Moving right along to Section 2, Permanent Alimony under Section 25 of the HMA. Let's see how this builds as we transition from those initial interim proceedings to the final decree stage. You've really got to be able to compare Section 24 and Section 25 directly in your sleep. As we just saw, Section 24 is ordered during the proceeding for basic support. Section 25, though, is permanent alimony and maintenance. This one is ordered by the court while actually passing the final decree. The payout? It can be a one-time lump sum or it can be periodic, like a monthly payment. But importantly, it cannot exceed the lifetime of the applicant. And unlike that interim stage, Section 25 takes a much wider look at the whole picture. It accounts for the respondent's income, the applicant's own property, and, very notably, the conduct of both parties. It can even be made a charge on the respondent's property. To really grasp how courts calculate this, you absolutely need to know the 2007 case of Bharat Hedge versus Saroj Hedge. Frame this as a crucial 7-point mental checklist for your exam. The court looks at reasonable wants, the lifestyle and status that needs to be maintained, the income and property of the other party, the number of dependents, the liabilities of the non-claimant, and of course, basics like food, clothing, education, and medical expenses. Now look closely at that 7th point. The court is actually allowed to use some guesswork when all sources of income aren't fully disclosed. Honestly, it's a super powerful tool against hidden wealth. But hey, these permanent orders aren't carved in stone. Under Section 25, if circumstances change, the order can be varied, modified, or just totally rescinded. The statute specifically points out that if the wife is not chaste, or if the husband has intercourse outside wedlock, the other party can step right in and ask the court to pull back or change that maintenance order. Let's look at a pretty fascinating modern application of these rules with the Bhagyashree versus Jagdish case from 2022. Check out this timeline. The couple got married in 1992. Fast forward, a divorce was filed and granted in January 2015. But here is the twist. The wife was earning roughly 30,000 rupees. While the husband was unemployed, he had actually helped the wife with her studies earlier on. In 2015, the wife filed under Section 25, while the husband filed for interim maintenance under Section 24. In 2017, he was actually awarded interim maintenance of 3,000 rupees plus arrears, which got increased later. Then, in 2021, a writ petition argued the order was invalid since the divorce was already finalized. But in 2022, the Bombay High Court upheld the maintenance order. It perfectly illustrates that yes, an unemployed husband can absolutely claim maintenance from an earning wife, and those legal obligations can extend way past the final divorce date. All right, Section 3. Child custody under Section 26 of the HMA. So, shifting gears from financial reliefs, consider this highly relevant modern dilemma. What happens when one parent relocates internationally right in the middle of a bitter litigation, making standard in-person visitation completely impossible? Well, the foundational rule here is Section 26. This section empowers courts to make interim orders regarding the custody, maintenance, and education of a minor.
And just like Section 24, these orders should be banged out within 60 days. The court must prioritize the minor's wishes wherever possible. And again, even after the final decrees, the court can revoke, suspend, or vary these orders if an application is made. And this brilliantly illustrates how the Supreme Court handles that exact relocation question we just talked about. Let's look at the incredibly recent case of Manush Dhankar versus Niharika from 2025.
In this case, the couple married in 2012. But in 2017, right in the thick of litigation, the mother packed up and left for Ireland with the child. So the child was no longer in India, making standard visitation literally impossible. The Supreme Court stepped in, heavily emphasizing the best interest of the child principle. They noted that, despite the flaws of the parents, both parents are needed for a child's development. They firmly stated that international relocation shouldn't just amount to an emotional loss for the child or the other parent. So, as a modern solution, the court awarded video conferencing rights on alternate Sundays. You definitely want to remember this for your exams. It's a prime example of Section 26 adapting to the digital age.
Moving on to Section 4, property disposal under Section 27 of the HMA. So this fourth signpost deals with a very specific and honestly often misunderstood issue, property giving around the time of the marriage. To really understand Section 27, you've got to lock in this precise piece of legal terminology, Sridhan. In Hindu law, Sridhan is defined as the absolute property of the wife. It is hers, entirely. Now here's where students always get tripped up on exams. The 2022 case of Babadal Yadav versus Sonu Yadav breaks this down perfectly. Section 27 of the HMA actually has a very limited scope. It only allows the court to make provisions for property presented at or about the time of marriage, which might belong jointly to both the husband and the wife. The court in Babadal Yadav clarified that Section 27 is really just an ancillary remedy. It is not the primary tool for a wife to recover her absolute Sridhan. Actually, scratch that. If a party needs to recover absolute Sridhan, they must take refuge under the inherent powers of the court, specifically Section 151 of the Civil Procedure Code. Make sure you keep that distinction crystal clear.
Finally, Section 5, Appeals and Validity, under Sections 28 and 29 of the HMA.
We're at the procedural wrap-up of our explainer. Section 28 is beautifully simple, but it is vitally important. If you're going to file an appeal against decrees or orders made under this Act, your appeal window is a strict 90 days, period.
And we finish our recap with Section 29, the savings provisions. Think of this section as a protective shield for marriages that are otherwise legally valid. It explicitly states that a marriage cannot be deemed invalid simply because the parties are of the same gochara, or because they're of a different religion, or even a different caste or community. Furthermore, Section 29 makes it clear that the Hindu Marriage Act does not strip away any recognized customary rights to obtain a dissolution of marriage, and it absolutely doesn't affect any proceedings under the Special Marriage Act.
Well, that covers our targeted recap of Sections 24 to 29. As you review your notes tonight, I want to leave you with this final strategic question. If you were litigating a Section 25 maintenance dispute tomorrow, would you build your case relying strictly on the disclosed income documents? Or would you aim to trigger the court's power of guesswork under that Barhat-Hegde precedent? It is a fascinating tactical choice. Best of luck on your exam recap, study these cases closely, and we'll see you in the next explainer.